Okay, so we have the handout in front of us, right? And you'll notice that Article 15 of the New York State Penal Law has intentionally, knowingly, recklessly, and with criminal negligence, right? Now, I'm not going to read these verbatim. You should do that, but I'm going to explain them right now. So what does intentionally mean? Well, it basically means that when a person acts intentionally, their conscious objective is to engage in this behavior and to make something happen. So we all know when we say, yeah, the person acted intentionally, we know what it means. It means they intended to do it, right? And so their objective, their conscious objective is to cause the result or engage in the conduct. Knowingly is very, very closely related to intentionally because when a person acts knowingly, they're aware of what their conduct might cause or they're aware of the circumstances surrounding their conduct. So oftentimes in the law, students will say, oh, what's the difference between intentionally and knowingly? And I say to them, don't really dwell on that so much because intentionally and knowingly are often wrapped together in the law, meaning you understood your actions and you intended to do them. So you acted intentionally and knowingly, right? The difference in the culpable mental states really comes, or I should say the major distinction really comes with recklessly. What does recklessly mean? Well, in New York State, a person acts reckless when, and again, you can read the text from the penal law from the handout, but I'm going to explain it. Recklessly means a person understood the dangers of the actions they were about to take. They understood there were risks, but they disregarded the risks and they engaged in the conduct anyway, right? They understood, they perceived the actions, but they disregarded them. They didn't care, and they did them anyway, and someone got hurt. That's recklessly. So if that's recklessly, what's criminal negligence? Well, listen, in criminal negligence, a person doesn't perceive the risk, right? Remember, in recklessly, they perceive the risk and they disregard it. In criminal negligence, they don't perceive the risk, but any reasonable person would have perceived the risk. And since they didn't, their actions are unreasonable. So what does this all break down to? Well, first of all, the law treats these different culpable mental states differently. The most severe punishments come to people who act intentionally and knowingly. Less severe punishments than that come to people who act recklessly. And even less severe punishments to people who act with criminal negligence. Criminal negligence is almost like the tragic accident, but somebody's got to be held responsible. That's really kind of what it is in a lot of cases. So just think about it. When it comes to law and punishment, criminal negligence is the least severe. Recklessly is more severe than criminal negligence. And at the top of the heap, you have intentionally and knowingly, which are the most serious mental states, right? Okay, tied to that notion is another term that I want you to know, and that's strict liability offense. By the way, strict liability offenses are also in Article 15 of the New York State Penal Law. They're not in the handout, but they're there if you want to go online and take a look at them. But I'm going to explain what a strict liability offense is right now. A strict liability offense is a crime that does not care what your culpable mental state was at the time of the crime. It only cares that you did the act. So, for example, in New York State, burglary is a person enters or remains unlawfully in a building. It's burglary in the third degree, actually. A person enters or remains unlawfully in a building with the intent to commit a crime therein. Right away, bells should go off. You hear the word intent. The culpable mental state is intentional for that particular crime. Now, if we change gears and we went to, say, a gun possession, right? And that law says something like this: a person is guilty of unlawful possession of a firearm when they unlawfully possess a firearm. In that particular law, you don't hear anything about the mental state of the bad guy. You don't hear intentionally. You don't hear knowingly. You don't hear recklessly. You don't hear criminal negligence. None of those terms appear in that law or statute, which is another word for law. Statute, Statute, right? You don't hear those words. So a statute or a law which doesn't require the prosecution to prove your culpable mental state is known as a strict liability offense. So what kinds of crimes are strict liability offense? Well, basically, lots of them, right? You have a lot of weapons crimes, like the gun possession I just talked about, are strict liability. All of the low-level narcotic offenses are strict liability. When people get arrested for unlawful possession of marijuana, it doesn't say they intended to, they knowingly did it, they recklessly did it, they did it with criminal negligence. It just says they did it, and that's a strict liability offense. Virtually all of the offenses in the vehicle and traffic law, with the exception of reckless driving, are strict liability offenses. When you get a ticket or you get arrested for speeding, no one says, well, he intended to speed, he did it knowingly, he did it recklessly, he did it with criminal negligence. No, they say, we clocked him at 100 miles an hour, Judge, and the speed limit was 65 or 55. And so strict liability offenses mean the law doesn't care what your mental state was at the time. All they care about is that you did it. That's a strict liability offense. And while we're at it, two more concepts that I want you to get and you have to remember. One is mens rea, M-E-N-S-R-E-A, mens rea. And the other one is actus reus, A-C-T-U-S-R-E-U-S. So I'll spell mens rea again, M-E-N-S-R-E-A, and actus reus, A-C-T-U-S-R-E-U-S. What are these? These are Latin terms for culpable mental states and just the bad act. So the bad act that a bad guy does that's against the law is the actus reus. That's the bad act. The mens rea is the mental state, the culpable mental state. So let's go back to burglary in the third degree for a second. In New York State, a person is guilty of burglary in the third degree when they enter or remain unlawfully in the building with an intent to commit a crime therein. What's the actus reus? The act? They entered or remained unlawfully in a building. What's the mens rea? They did it with the intent to commit a crime therein. You see? So many, many, many crimes have in them defined the mens rea and the actus reus. Now, just to wrap this all up, certain crimes don't have a mens rea. They only have an actus reus, like low-level narcotics possession, like weapons possession, like the vehicle and traffic law. So those laws or statutes that don't have a mens rea, that's the mindset, those are called strict liability offenses. Make sense? I hope it does. Make sure you take a look at that handout. Okay, so continuing, on page 10, go down to where it says a crime. And just remember something, a couple of definitions again here, more definitions. Hope you got your pen and your notebook ready. So in New York, what's the difference between a felony and a misdemeanor? I have to tell you that students always get this wrong, and it drives me crazy, right? So here's before I tell you, before we talk about this, I should say, I want you to remember this phrase: felony more, felony more, felony more, felony more. Right? What does that mean? It means that in the state of New York, a felony is punishable by more than a year in prison. That's what it means. A felony is punishable by more than a year in prison. A misdemeanor, on the other hand, is a year or less in jail. A year or less in jail. So the way to think about it is, in New York, a felony is 366 days or more. A misdemeanor is 365 days or less, right? And while we're at it, what's the difference between jail and prison? Well, convicted felons go to prison, and prisons are run by states and the federal government and the military. And people who are arrested and awaiting trial on any charges or who have been arrested and convicted of misdemeanors go to jail. So if you're in jail, you've either been convicted of a misdemeanor, this is in New York, or you've been arrested on any charge. You could be arrested on a charge of murder and you're waiting your day in court. You're awaiting your day in court. You're in jail. But once you get convicted of a felony, where do you go? You go to prison. So let's go down to the bottom of page 10. It says there's a couple of definitions there. Criminal statute. I said that already on this lecture. A statute is what? A statute is essentially what? It is another word for law, right? Then they have an ordinance, and ordinances are usually local laws enacted by the local municipalities like the Orange County Board of Legislators, things like that. And then you have this term, the elements of a crime, right? What does that mean? Okay. Do you remember going back to burglary in the third degree when we just talked about the four culpable mental states and we talked about mens rea and actus reus? I hope you remember. It was only a few minutes ago. So let me explain what elements of a crime are. Every crime has elements. Some have one, some have two, some may even have three, right? The elements of the crime are what the prosecution has to prove beyond a reasonable doubt in a criminal case in order to get a conviction. So, burglary in the third degree in the state of New York, once again, is a person is guilty of burglary in the third degree when they enter or remain unlawfully in a building with the intent to commit a crime therein. A person is guilty of burglary in the third degree when they enter or remain unlawfully in a building with the intent to commit a crime therein. Okay, so how many elements are there in the crime of burglary in the third degree? Very simply, there are two. Listen closely. A person is guilty of burglary in the third degree when they enter or remain unlawfully in a building. There's one of the elements. They enter or remain unlawfully in a building. And then, with the intent to commit a crime therein, the mens rea, that's the other element. So in order for a prosecutor to convict someone in the state of New York beyond a reasonable doubt for burglary in the third degree, they have to prove both elements. They have to prove that you entered or remained unlawfully in a building, and they have to prove that your intent was to commit a crime therein. Elements of the crime. Make sure you understand them, right? Over on page 10 on the right-hand side, in that second paragraph, right in the middle of it, it says, designated crimes and their punishments change as society's attitudes change. This is an important concept. It's important to understand that law and punishments are a reflection of society's value system, where they are right then and there, and that's, that piece of time. And that's why laws tend to change as society's values change. Make sure you get the concept. So let's go down to the primary goals of criminal investigations. So I'm going to give you a definition of the goal of a criminal investigation. And it's not a Cacciatore original, by the way. I actually stole this from an FBI agent who was making a presentation, and he used this definition of the goal of a criminal investigation, and I thought it was so smart and so sharp that I grabbed a napkin and I wrote it down, and it was a long time ago, but I've used it ever since. And he said, the goal of any criminal investigation is to uncover the truth and deliver it with integrity. To uncover the truth and deliver it with integrity. That really is the goal of any criminal investigation. People talk about, the goal is to arrest somebody, or the goal is to do this, or the goal. No. The goal is to uncover or discover the truth and deliver that truth, whatever it is, with integrity, right? So let's go down to the bottom of page 10. On the right-hand side of page 10, the last sentence. It says, procedures to accomplish these goals are the focus of the remainder of this text. However, it must always be remembered that determining the truth is more important than obtaining a conviction or closing a case. Yeah, And then you have on the top of page 11, you have learning outcome number 2. It says the primary goals of a criminal investigation are, number 1, to determine whether a crime has been committed, to legally obtain information and evidence to identify the responsible persons, to arrest the subject, to recover stolen property, and to present the best possible case to prosecutors, right? Absolutely. And then going down right below it, right below the learning objective number 2, about 3 or 4 lines down, it says, thus, the first goal of an investigator is to assess whether the evidence corroborates a specific offense, right? Sure. In other words, does the evidence as it's being presented substantiate or corroborate? And by the way, corroborate means to verify, right? Does it corroborate a specific offense? If someone tells you a story and you're looking at the story, you're listening to the story and you're looking at the evidence and they don't match up, there's a problem, right? And, just to give you an example, you go to a domestic violence call and a woman insists that her husband did not hit her, but yet she's got a black eye and a bloody nose, right? Here you have a problem. You have a problem between the story and the evidence. Now switch the facts around and she tells you, yes, he hit me, he punched me in the face a few times, and you see the bloody nose and the black eye. That evidence corroborates, right? That is, it verifies what she's telling you, right? And let's go down to the paragraph below it. It says, in addition to proving that a crime has been committed, investigators must determine when the crime occurred and who committed it. Determining when the event occurred is critical for checking alibis and reconstructing the modus operandi, otherwise known as the MO, that is the preferred method a criminal uses when committing his or her crime. Okay, so you're going to hear me use MO or modus operandi a million times in this course. What does it mean? The MO is the way a criminal does his or her crime. It's kind of like their style. That's their MO, right? If a criminal favors mugging old ladies on the day they get their Social Security checks, that's their MO, right? If a burglar favors climbing up terraces and breaking into a little window on the terrace of an apartment building, that's the MO, right? So make sure you understand what modus operandi is. In that same paragraph on page 11, going down to near the bottom of it, it says, however, investigators must always be vigilant for the potential for copycat offenders, and suspects should never be eliminated simply because their known MO does not fit the crime being investigated. Yeah, and the reason for that is simple. People can change their MO. They're not locked into it. You hope they kind of stay with it because it helps law enforcement identify them, figure out who they are. But they're not locked into it. You can be a burglar one day and a street robber the next, right? A burglar breaks into someone's home. A street robber actually accosts a person and steals from them, right, with force. And then the paragraph below says, while committing crimes, people may make mistakes. They almost always leave some type of evidence behind. Sounds like Locard. And then down in that same paragraph, it says, more often, however, criminals leave trace evidence, less visible evidence such as fingerprints, small particles of glass or dirt, a faint footprint, body hairs, clothing fibers. Investigators search for evidence using methods discussed in Chapter 6. And yeah, that's all Locard's principle of exchange right there, right? Go up to the top of page 11. In that first paragraph, right near the bottom of that first paragraph, it says, many cases have insufficient evidence, no witnesses, and no informants to provide leads. Solvability. Factors will be discussed later in this chapter. And the next paragraph says, investigators learn to recognize when a case is unsolvable, but only after all leads, that means avenues bearing clues or potential sources of info relevant to the crime, after all leads have been exhausted. A successful investigation is one in which, and there's a laundry list of 6 things there, right? A successful investigation, a logical sequence is followed. All physical evidence is legally obtained and analyzed. All witnesses are effectively interviewed. All suspects are legally and effectively interrogated. Remember, we interrogate suspects, we interview witnesses. All leads are thoroughly developed. And lastly, all details of the case are accurately and completely recorded and reported. That is a successful criminal investigation. Let's go down to the bottom of page 11. It says basic investigative functions, the responsibility of all police personnel. It says early police organizations were one unit, one purpose departments, with everyone performing generalized functions, including criminal investigations. However, over time, departments perceived the need for specialization because, and then there's this list. Let me introduce you to two terms right now. In police departments, you have generalists, and specialists. What does it mean? Well, a cop on patrol who answers all types of calls and conducts all types of preliminary investigations, they're generalists. But if someone is a narcotics detective or a crime scene detective, or they're an investigator with the domestic violence unit, then they are specialists because they specialize in handling this type of offense. So obviously in larger departments, you're going to see a lot of specialists because they have the resources to do it. In smaller departments, probably not so many specialists. Why? Because they're smaller and they probably lack the resources, right? So let's flip the page, go to page 12. So on page 12, they continue talking about specialists and generalists. And the third paragraph down, it says, today, researchers are studying the extent to which specialization should remain. And then skipping down a little bit, it says, several specific factors appear to support the training of all officers to perform investigative duties. And then there's a whole laundry list there of why we should train all officers. And by the way, while we're at it, let me just say that we should. Every cop in the world, whether they're in uniform, on patrol, should be taught the basics of criminal investigations because 99.99% of the time, they are the first responder. And it would be ridiculous to have cops who respond to crimes more often than not, way more often than not, they're the first people to respond and have no or little or no training in criminal investigations. So today, the push, whether it's small department or large, the push really is to train all of your officers to be investigators to some degree, right? And then look at the paragraph below those, about like seven bullet points. It says, the reality is that the majority of policing in the United States today occurs not in large urban law enforcement organizations, but in small agencies serving relatively small jurisdictions where departments do not have the luxury of a dedicated division of detectives. As such, the ultimate responsibility for criminal investigation lies with all police personnel, regardless of rank or title. Absolutely, positively true. And then at the top of the page, page 12, it says, uniform patrol has traditionally been considered the backbone of all police departments and has been responsible for the initial responses to crimes. Absolutely true. Involving frontline officers in the entire investigative process creates interest in crime prevention as well as investigation because you're bringing those cops that are on patrol into the game. You're not just having them respond like, tin soldiers, to use an old school term, right? Let's look at the paragraph on 12 that begins, the trend toward having all officers assume a more active role in investigating crimes allows patrol officers more responsibility when responding to a call and enables them to conduct as much of a follow-up investigation as their shift and their areas of patrol will permit, right? The importance of a patrol officer's investigative role cannot be overemphasized. And then it says, last sentence down there, it says, regardless of whether departments have specialists or generalists, their goal is the same, solving crimes. Make sure you take a look at Learning Outcome 3. And then moving over to page 13, it says, before looking at the characteristics of an effective investigator, it is prudent to briefly mention here the function of the crime scene investigator, or CSI, a specialist in the organized scientific collection and processing of evidence. Well, you guys all know what CSIs are because you watch tons of it on TV. But really what I want to focus here is on the term the CSI effect, right? The CSI effect. The CSI effect refers to people's unrealistic expectations about crime solving because of the misinformation they have gathered from television. I'll say that again. I said it off the top of my head, so it might not be identical. But the CSI effect refers to people's unrealistic expectations about the ability to solve crimes based in large part on how TV misinforms them. So, for example, I remember watching a couple of these crazy cop shows with my mother years ago, who loved them before she passed away. And, they would get like the answer to some toxicological question in 5 minutes, or they would run a print and get an ID off an old picture, in seconds. And, or there was ballistic evidence in every case, or there was fingerprints found at every scene of every crime. Those are all part of the CSI effect. TV leads people to believe all of these things. And quite frankly, it really becomes a problem when you're a prosecutor and your jury is knowingly or unknowingly tainted by the CSI effect, because then they have unrealistic expectations. And I'm going to give you an example. Casey Anthony, I'm pretty confident, murdered her little daughter, Kaylee. The jury, on the other hand, found her not guilty. And one of the things they said was, and the jury said this after the trial, they said, well, the medical examiner couldn't give us a specific cause of death for the baby. So if they couldn't do that, how could we find her guilty of murder? Well, that's the CSI effect. Why? Because the baby, the deceased baby, Kaylee, she was murdered and then wrapped in plastic and thrown in a swamp. And over time, animals began to eat her and she began to decompose. And that process basically prevented the medical examiner from coming to an accurate conclusion about exactly what killed her. But toddlers don't kill themselves and wrap themselves in paper bags and plastic bags and throw themselves in swamps. So one would have had to conclude that the person who lied about her daughter's appearance, who lied about being with her daughter for at least a month, who lied about a million things, by the way, who was the last to see her alive, who lied about so many things, including there was a babysitter that was completely fictitious. It was just a million things. And if you don't believe me, go on the internet and check up on it. Make sure there's a credible source, please. But the CSI effect, I believe, helped get Casey Anthony found not guilty in that crime when I think she was clearly guilty of murdering her little daughter. So the CSI effect is a really serious thing. Characteristics of an effective investigator on page 13. One of the terms, obviously, listen, investigators have to be open-minded. They have to be smart. They have to be, analytical. No question about it. But they also have to be culturally adroit. And we'll find that term in Learning Outcome 4 on the top of page 13, right? And what is culturally adroit? Someone's culturally adroit when they can interact with people no matter what the differences may be between the investigator and the person they're interacting with. So in other words, it doesn't matter if there's a big difference in their education levels, if their race, their religion, their ethnicity, their socioeconomic class. If an investigator is culturally adroit, they can basically respectfully deal with every person, right? And it's really, really imperative that great investigators and great police officers and great correction officers and great court officers, et cetera, that they're culturally adroit, because there are, and I'm just going to get on my soapbox here for 2 seconds, there are many more things that make us similar than make us dissimilar. You know what I mean? So being able to relate to people no matter who they are and no matter who you are is being culturally adroit, and it's an important characteristic for good law enforcement people, right? And it says right below it, below the blue box, it says investigators meet and talk with people from all walks of life, And that's totally true. And they have to be able to do it. And then in page 13, it mentions logic, it mentions decision making. And I think I'm going to leave it right there, and we'll come back with the description of, this is part 2, by the way, right? Comes back with the descriptions of facts and opinions and inferences, and I think that's where we'll pick up. So that being said, the end of part 2, if you notice what happened, part 1 kind of shut off without me saying goodbye, and that was an accident when I was recording it. So we had part 1, this is part 2. We'll come back with part 3, and we'll pick up on page 13. And as always, thanks for listening, and I'll see you on the blog.